Everyone's talking about the world's first regulated AI law firm, but I wanted to go deeper. So I've created an exclusive podcast series that goes beyond the buzz. Over the next few episodes, I'll be sitting down with the CEO, Philip Young of Garfield Law. We've put together the most pressing questions from professionals across the legal industry, and we're addressing them in this series. In this episode, we discuss when should legal AI products be regulated?
One of the takeaways I've taken from this chat with you, Holly, is that I need to go and get a haircut pretty urgently.
I'm going to ask you a serious question now.
Regardless of AI laws, when it was written, no one ever contemplated that there might ever be legal services provided by AI.
Everything's going wrong and it's like Frankenstein. You invented this thing and it's just going crazy.
Yeah, I'd like to get away from the word Frankenstein then.
That's hilarious. So, Philip, I'm really, really excited to have you back for round 2 because I feel like round 1, everybody was asking me questions and wanted to know more information, and I feel like we can clarify those points in this episode.
And so I suppose I say me again, and I hope your viewers are not horrified by that.
I do want to delve a little bit deeper into the regulatory part of things. We did touch on this when we first spoke, but a lot of people have been asking me and have been very interested in that. So I just wanted to ask you, at what point does an AI product cross the line into needing legal regulation?
Cool. Law time. Love law, don't we? That's one of the great things about being a lawyer.
Yeah, me and you are both law geeks.
Yeah, exactly. Yeah, law geeks and nerd geeks. What a combination, eh? Yeah, so this is a really interesting topic. So I think one of the first things that surprises lawyers is if they've not looked at the regulatory framework closely, and most lawyers probably haven't because they haven't needed to, it's a regulatory lawyer type question, is the fact that merely providing legal advice doesn't necessarily mean you have to be regulated. But when you stop and think about it, that makes perfect sense because people, non-lawyers, provide legal advice frequently, during their lifetimes, because people might say things like, oh, well, you've got that problem, why don't you go and read the contract and see what the contract says? Or they might say something like, oh, you can't drive at more than 30 miles an hour down there, that's a 30 mile an hour zone. I mean, that's essentially advising people on the law. So we do it day in, day out, whether we know we're doing it or not, and whether we are particularly intending to give advice like lawyers would give. And other professions do the same. I mean, accountants give advice on tax and VAT, which is the same advice that a tax lawyer might give. So legal advice by itself is not necessarily something that you need to be regulated to provide. And there's cases on this, and the most recent case was Baxter and Doble back in 2023, decision of Mr. Justice Kavanagh, where he referred back to a previous case that had said exactly the same thing. So what that means is if you were going to build an AI product and all it did was give legal advice, I'm not convinced you need to be regulated for that product. And that might have some pretty big implications as to what you could do in your terms and conditions about limiting your liability, whether you have to carry insurance, how much, those sorts of things. But then you'd have to be very careful about what it actually does, because giving advice is one thing, helping you with process is something wildly different. So moving on to the process side of things, if you're not familiar with the Legal Services Act, basically it defines certain things as reserve legal activities. And it basically says if you're going to conduct a reserve legal activity, you've got to be regulated. Certainly from a contentious perspective, the two that leap out as being really relevant is exercising a right of audience. I think we all know what that is. I mean, that's going to court, making oral submissions or making written submissions to a court or calling a witness. Clearly you've got to be regulated to do that, unless you're acting for yourself, in which case you can do that for yourself. But the more interesting one, certainly from Garfield's perspective, is conducting litigation. And that's defined in the second schedule to the Act. And it's one of those definitions that you could see the lawyers started with the easy stuff to define, and then they got onto the difficult, ambiguous, vague stuff, and then sort of had a catch-all definition. So they defined it as the issue of proceedings before any court in England and Wales. And we all know what that is. And the only question there might be, well, what is a court? And you can find a definition of what that includes in the Act as well. And it includes things like listed tribunals. So if you're building an AI product and you were doing some form of litigation process but it might be before a sort of obscure sort of tribunal. You might want to look at whether that is a listed tribunal, whether it's regulated, and whether therefore you need to be regulated to do that. The second limb of the definition is the commencement, prosecution, and defence of such proceedings. That's a bit vaguer, but I think we probably put our fingers onto what that is. It's doing things to progress the process. So if you look at the case law, drafting pleadings, sending letters to the other side, paying the court. If you look at it in its totality, you can see what is progressing a case, and that's where legal advice may come into the net of being regulated. Because if you're providing legal advice as part of that process, then that is a reserved legal activity. Even if you were doing legal advice outside the process, it wouldn't be. And then you enter the really vague part, which is the performance of any ancillary functions in relation to those proceedings. I'm not sure what that means. I don't think any judge is sure what that means, because there's been no case that's really sort of defined it categorically. I think the most you can say is that judges look at everything that's been done as a whole, and then they say, is this really conducting litigation or not? So, that's the definition. And if you're thinking from a designing an AI product perspective, I think the questions you'd ask yourself are, first of all, is what you're doing purely pre-action? Because if it is, you're not going to need to be regulated. The cases are pretty clear on that. If, on the other hand, you're doing something that is issuing proceedings, then you're probably going to have to be regulated. If you're doing something that involves the progression or defence of proceedings, then it becomes a grey area. And it depends on what your product is actually doing, and is it just a ministerial thing, or is it a substantive thing? And I think the more narrow your product is, the more likely you are not to need to be regulated. So I've been told by some very eminent family lawyers that doing things like drafting consent orders and sending them to the family court is not a regulated activity. And apparently there's a case on this. So you could see that you might have a very limited product that just does that. Whereas if you had a product that, I don't know, family did lots of other things like draft the Form Es and all that sort of stuff, then you'll head towards regulation. So I think it's a really interesting philosophical area, which is if you're thinking about building an AI product or looking at an AI product, and you're thinking, do I have to be regulated or not? You end up having to ask these questions. Is it just purely giving legal advice? Is it just doing purely pre-action stuff? If it's doing stuff relating to the proceedings, how much is it doing? Is it substantive? The more it's going to be doing, the more likely it is to be regulated. Those sort of questions. But then, of course, some people are going to want to be regulated. Like we wanted to be regulated. We proactively went out to the SRA and said, hey, we want to be regulated. And I think then the more you could show that what you're doing falls very clearly within what courts have said is definitely conducting litigation, the easier you're going to make it for the SRA to say, yes, we can regulate you and you should be regulated.
I like how you went to the SRA and were like, come and regulate us.
Please. Pray. I sort of like, praying, please regulate us.
That's so good. No, but it's important though, because I know that you provide Garfield to law firms as well. So law firms, they've got this level of security. They know you're regulated, so it just makes sense. Like you're going to be compliant. So what do you suggest then? Let's say a law firm is looking for a solution like yours, and they're looking at different providers. Is it risky for them to use a provider or a legal tech solution that is not regulated? And if so, what sort of things do they need to look for, would you say?
I think this is a horses for courses type thing, because for a law firm, it depends very much upon what pain problem they're trying to solve. And then once they've identified that, then whether or not they need a product that is actually regulated, or whether they gain anything from that, like a sense of comfort or something like that. There's a lot of AI law tech products already that are clearly not regulatable and are not regulated. I don't think Harvey, for example, is regulated as far as I know. I could be wrong on that, in which case, apologies to Harvey, sorry. And I saw some other products a couple of weeks ago at the Legal Tech Talk conference that weren't regulated. And I think for those sort of products, if you're a law firm wanting to buy a solution to that problem that the product does solve, then you're not going to really care if they're regulated or not, because you don't need them to be regulated, and they might not even be regulatable. If you're buying, on the other hand, a product where there is some value to you, either the product has to be regulated or there's value to you if it is, then of course, then that's something I think you're going to look for. The oddity about Garfield when being used by law firms is that the law firm is itself regulated. And so you can argue that we wouldn't need to be for that use case. It just so happens that we are. I think it's good that we are, because I mean they are discharging their own responsibilities to their client. I think it comes down to, do you need it and what does it give you?
I do get you. If the law firm is regulated, then that's sufficient for the client, for their client. But it adds an extra level of security if the solution is regulated as well. But as you say, not all of them are regulatable. I've wasted hours drafting contracts in my business. I've used clunky templates, even written from scratch, looked into paying lawyers. I've even tried ChatGPT, but it just didn't hit the mark. I knew there had to be a better way. And then I found this, Air Counsel, an AI contract drafter built by lawyers for lawyers. I spoke to the team at Air Counsel and they use it for their own legal work. And they're improving it every single day based on real life feedback. It actually does the heavy lifting for you. It researches your jurisdiction's laws and nuances and picks up local drafting quirks and even matches your tone and style. It then builds a ready-to-edit Word document with hyperlinks, numbering and a table of contents. It's so quick. I was so impressed when I used it. What I love about it is you can ask it to draft any contract you like, and it will even give you suggestions for appropriate terms or clauses that you'd never even think of. If you're still spending hours drafting contracts the old way, you don't have to anymore. This changed everything for me. If you're a lawyer, business owner, service provider, it might just do the same for you. And Air Counsel have been kind enough to sponsor this episode, and I'm so excited to spread the word. It's the most sophisticated contract drafting software I've used. To get your free 7-day trial, just go to the description of this episode. Give it a go, and don't forget to let me know how it changes your workflow.